I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about the administration of justice in Calcutta 1690 to 1726. My dear viewers, the objectives of the present module are firstly introduction, then administration of justice at Calcutta, then Jamidar's courts, Qazi's court, Nawab's court, and finally the conclusion. Dear learners, let's begin with the brief introduction of the topic. The history of the legal system in British India traces back to the establishment of the East India Company. During the early days of administration, justice was not prioritized and there was a lack of separation between the executive and the judiciary. The judges lacked expertise in law and the company did not place much emphasis on judicial independence, fair justice and the rule of law. Gradually, the East India Company grew in power and strength. After the death of Emperor Aurangzeb in 1707, when the Mughal Empire began to disintegrate, the East India Company got an opportunity to lay its foundation in India. In India, it was in possession of 3 factories and settlements at Bombay, Madras and Calcutta. Gradually, under the changing circumstances, the company exercised wider authority at Bombay, Madras and Calcutta. A president or governor and council at the 3 places governed English factories and settlements. Members of the council were generally taken from senior merchants of the company. The governor, who was the executive head with his council, was also looking after the administration of justice in his settlement. The company derived the power and authority which it exercised in its settlements from 2 different sources. The Crown and the Parliament in England on one hand and the Mughal Emperor and other native rulers in India on the other. At the 3 settlements of Bombay, Madras and Calcutta, the company had to deal with different local political powers also. At Bombay, the company exercised its powers as the representative of the English crown. The position of Madras was different. Madras was granted to the company by the local Raja in 1639. The company ruled over both Englishmen and Indians, but its authority over the former was derived from the royal charters, while its power over the latter was derived from the grant of the local Raja or Nawab. At Calcutta, the company purchased the jamidari of the 3 villages, which later came to be known as Calcutta. There, the company exercised its authority under the Mughal emperor's grant of jamidari. The policy of the company therefore varied according to the principle by which control was to be exercised in all these settlements. By the end of the 17th century, the East India Company was firmly established in India at Surat, Madras, Bombay and Calcutta, though it declared its mission purely as a trading company. These activities of the company in fact paved the way for the adoption of a new policy by the British Parliament in the beginning of the 18th century regarding its aims and relations with India. The gradual passing of the various charters for regulating the company's acquisition of territory and administration of justice in India from time to time may be said to be gradual but inevitable steps on the road that led up eventually to the setting up of the British Empire in India. Dear learners, let's understand the administration of justice and development of courts and judicial institutions in the Presidency town of Calcutta. The English company's settlement at Calcutta was quite different from that of Bombay and Madras. In the year 1668, the grandson of Aurangzeb, Azimush-Shan, and the Subedar of Bengal gave Jamidari of villages Calcutta, Sultanati and Govindpur for annual revenue of 1195 rupees to the East India Company. The foundations of Calcutta were laid on 24th August 1690 under the leadership of Job Charnock. In December 1699, Calcutta became a presidency. Therefore, the president and governor and council were appointed to manage the settlement of the state. The company, as a jamidar, became entitled to all the functions and powers within the jamidari territory. This proved a historical event, as the grant of jamidari rights empowered a foreign company to exercise all those powers which the native jamidar were authorized to have under the Mughal administration and judicial system. The company secured a legal and constitutional status within the framework of the Mughal administrative machinery. As a jamidar, the company got all the powers which the other zamidars of Bengal received at that time. Now, what were jamidar courts? In the Mughal Empire, jamidars got no significant judicial powers, but collected the revenue and maintained law and order in the jamidari area or villages. However, the company took full advantage of this authority and appointed a collector to control the administration of all the 3 villages. The collector began regularly to hold jamidari court for both civil and criminal cases. The jamidar court was also called kacheri. The jamidars of Bengal were to collect land revenue and maintain law and order in their jamidari area. They could decide only civil matter, and appeal of this court was placed in Nawab's court in Murshidabad. Jamidar court could give death sentence, but it should be confirmed by Nawab court. The appeals went to the Nawab's court in theory, but in reality not many appeals were actually taken. The zamidar could even award capital sentences, but only with the confirmation of the Nawab's government. The jamidar charged high fees for deciding civil cases in their courts. The judgments by jamidars were mostly discretionary. There was no definite body of law which they administered. The zamidari functions of the company within Calcutta were given to an English officer, the collector or the zamidar, who was a member of the Governor's Council. He discharged judicial powers in all cases, civil, criminal and revenue. Criminal cases were decided quickly and without a jury. The usual methods of punishment were whipping, fines, imprisonment, banishment and death. Death sentence was inflicting by whipping to death. The Jamidar's court was confined not only to the Indians but also tried cases of petty crimes and misdemeanors committed by the Englishmen. However, serious crimes of Englishmen were tried by the Governor and Council under the authority of the Charter of 1661. The Zamidar also tried civil cases arising among the Indians. The judge acted in a quick manner. Appeals lay to the governor and council. The collectors or jamidars took charge of the revenue cases also, since they were responsible for collection of land revenue. Next were Qazi's courts. For judicial purposes at that time, Qazi's courts were established in each district or sarkar, pargana and villages. They handled civil and criminal matters. Normally, village panchayat solved all problems excepting serious crimes. In Hindus, elders or Brahmins solved the problems. The judicial system was simple, as everyone knew each other and transactions of each other. Mughal kings never paid any attention to the judicial system, and the judicial department was not very well organized under the Mughals. When the Mughal administration structure started disintegrating and the Nawab's authority weakened in Bengal, degeneration in the ranks of the Qazis set in. The post of Qazi was sold many times. The highest bidder became the Qazi. Justice was purchased. Corruption was rampant. Qazi never got a salary. So, the Qazi could fine the criminal and earned money. After this, he also demanded money from the complainant for giving him justice. Qazi administered justice in succession claims and in ensuring succession and of course marriage disputes. Mufti was a learned jurist by extension of law. The Mufti himself did not decide the case, as his duty was only to help the Qazi to decide the case. Next was Nawab's court. The Nawab's court was theoretically the highest criminal court, as the Nawab was the head of the Nizamat, making him responsible for the maintenance of law and order by administering justice in criminal matters. The Nawab, with due course of time, also started functioning like the Qazi court. While earlier the Diwan used to preside over the court for civil cases, later on the Roga-e-Adalat Diwani, deputy of the Diwan, came to exercise the judicial functions of the Diwan in civil and revenue cases. The Diwan, that is, the head of the Diwani, was the highest court in civil cases. The court of Nawab was a criminal court. There was no proper demarcation as such, so the court also used to undertake property related issues. Dear viewers, let's understand Fauzdari court. Fauzdar was a police officer whose job was to suppress a serious crime. Kotwal took cognizance of petty criminal cases and Muhtasib took cognizance of drugs. The Muhtasib was in charge of alcoholism, liquor sales and the inspection of fake weights and mayors. Thus, the administration of justice in Bengal was in poor condition at the time of arrival of the British, and an important factor responsible for the distortion of justice was the uncertainty of law, as there was no regular system of law. Inheritance and succession claims as well as marital disputes were handled by the Qazi. Mufti, a qualified jurist, assisted the Qazi in carrying out his judicial duties. The collector decided criminal cases of the natives of 3 villages, Sultanati, Gobindpur and Calcutta. The criminals were punished by whipping, imposing fines, imprisonment, banishment or work on roads. Capital punishment was given only after confirmation by the governor in council. In Calcutta at that time, the collector enjoyed all the powers up to the year 1727. With the Charter of 1726, the new system was started in Calcutta Presidency. Before this charter, the authority was given by the company and Jamidar, but the Charter of 1726 was a royal charter. After the royal charter, courts got their authority from the British Crown. Dear viewers, it's noteworthy to note the reforms introduced by the Charter of 1726. As discussed earlier, in 1700 the East India Company appointed an English member of the Governor's Council as the collector of the Jamidari. The collector was empowered to collect revenue and decide civil, criminal and revenue matters. While in case of other Jamidars, a capital sentence was executed only after confirmation with the Nawab, and appeals in civil cases lay to the courts at Murshidabad. But the British within their own Jamidari took permission for awarding death sentences from the Governor and Council without making any reference to the Nawab. Also, appeals from the collector's court in all cases went to the Governor and Council and not to the Nawab's court. Thus, from the very beginning, the company's representatives were very authoritative and the company sought to act as a territorial sovereign as far as Calcutta was concerned and tried to reduce the Nawab's authority from the governance and administration of Calcutta. Thus, here too the judicial system was very elementary and was quite partial. This system continued till the Charter of 1726 was brought out. While till now the judicial system was based on the company's authority, with the Charter of 1726, it derives its authority from the Royal Charter. The collector retained only minor criminal cases and serious offences were transferred to the Governor and the Council. Appeals were made from the collector's court to the Governor and the Council court. The collector could also give punishment like whipping, imprisonment, fine and work on the road. Collector needed the permission of the Governor and the Council for capital punishment. The cases up to Rs 200 were decided by the Panchayat. The cases up to Rs 100 were decided by the Kachari, and those above 100 were decided by the Governor and the Council. Thus, the judicial system of Calcutta was not good, as all judicial power was vested in a single person known as collector, who was an executive officer. It should be noted that the judicial system in Calcutta before 1727 was based on company's authority. After 1727, the authority was taken from the Royal Charter. Let's understand the introduction of English laws in India. The Charter of 1726 made it possible for the company to introduce for the first time English laws side by side the personal laws of Hindus and Muslims. The subsequent charters accelerated this process. This may be explained with the help of case entitled Mayor of the City of Lions versus East India Company. In this case, one Martin, a native of France, had left behind immovable properties in Calcutta and Oudh. A question arose as to a will made by Martin, that whether the English law which prohibited aliens from holding land in England was applicable in India also. The Calcutta High Court applied the English law and declared that the property of Martin be escheated to the British Crown. The Privy Council in appeal overruled the Supreme Court's judgment and held that the principle of English law regarding the incapacity of an alien to hold landed property in England had no application to the presidency towns like Calcutta, which was acquired in a different country and had a different government. The Privy Council was of the view that application of such a law would cause great hardship and inconvenience to the settlers in Calcutta. Similarly, in AG of Bengal versus Rani Surnomoi, the property of a person committing suicide could not be forfeited to the government because of the English law was held inapplicable to India. Then, in Bhumi Mani Dosi versus Natobar Vishwas, the English common law was applied and the right to recover damages for slander was allowed. In Naroji versus Rogers, the Bombay High Court held that English law of immovable property was applicable in Bombay. In regard to the law of limitation, the Supreme Court once made it applicable, but later on the view was reversed and it was made inapplicable to Hindus and Muslims. In Param Shuk Das versus Rashid, it was held that the English law regarding prohibition of arrest on Sunday was inapplicable to a Muslim, India not being a Christian country. In Savage versus Bancharam, statute of frauds requiring 3 witnesses to a will was held to have been extended to India. In matters of contract, law of champati and maintenance was not made applicable, and it was held that matter should be decided according to the personal law or usages of the defendant. Thus, a contract violating the principles of champati and maintenance could not be declared void in Pichakutti versus Kamla Naikam. Now, let us understand the defects of administration of justice in Calcutta. At the very beginning, the representative of the company in Calcutta claimed and exercised more powers than what he was assigned as a jamidar. Thus, from the very beginning, the company wanted to be a territorial sovereign in Calcutta, where it tried to take out the authority of the Nawab. Calcutta, because of its late foundation, did not witness the vigorous judicial reforms that were introduced in Madras and Bombay. The beginning of major reforms in the administration of justice at Calcutta began in 1727 with the establishment of the Mayor's Court and the Court of Governor in Council under the Charter of 1726. My dear learners, on the basis of foregoing discussion, it may be concluded that before 1726, administration of justice in Calcutta, like Bombay and Madras, was essentially executive oriented. There was no separation between the executive and the judiciary. The executive even enjoyed overriding powers to appoint or remove the judges. Thus, the judiciary was subordinate to the executive. It is also evident that the judicial administration of this period was that the judges were non-professionals and did not possess adequate knowledge of law. However, by the end of the 17th century, an effort was made to induct persons well versed in law as judge advocate in Madras, Bombay and Calcutta. But the experiment was not very encouraging, and the company was reluctant to appoint lawyers as judges in its courts. The judicial system at Calcutta was extremely rudimentary and was not at all conducive to the impartial administration of justice. All judicial powers were concentrated in the hands of a single individual, that is, the zamindar or collector. He was primarily responsible for the collection of revenue from the zamindari land. However, he was also delegated the functions and powers of adjudication in all cases of criminal, civil and revenue matters. As a result, the legal system was quite basic, inadequate and ineffective. Another aspect of the administration of justice was that the judgments delivered by the company's court were not recognized by the courts in England, as the judges of the company's courts were laymen without having adequate knowledge of law and legal procedure. Hence, their decisions were mostly erroneous and controversial. The judicial system of the company's settlement in Bombay, Madras and Calcutta lacked uniformity and certainty. Each settlement had its own judicial arrangements, which were quite distinct from the other. This form of judicial system continued till 1727, when it was replaced by the Charter of 1726. Until the new charter, the judicial system was based on the company's authority as zamindari. After 1727, the system derived its authority from the Royal Charter. It was only through the Charter of 1726 that a uniform judicial system was introduced in the three presidency towns of Bombay, Madras and Calcutta. With this, we come to the end of this lecture. Thank you very much.